Thank you for that contribution. I'd like now, with your permission, to hand you over to Justice Michael Peart, who's agreed to come along and talk to us today and to formally launch this initiative. Thank you very much.
I was going to try and put this back in here and speak without having to hold it in my hand. I just realized, literally, perhaps I had better put it in my hand. I've just realized before I stood up to come to this podium that the last 3 pages of what I prepared to in order to speak to you have been left somewhere in the printer and are not in my hand. So when I come to an abrupt end, that's the reason. But I do thank you very much for inviting me to speak at the opening of the Chartered Institute of Arbitrators Court Alternative Mediation Service. I was wondering, in fact, why I was asked by Bill Holohan this year to join him as his guest at your very enjoyable annual dinner a couple of weeks ago. I should, of course, immediately have recalled that there is no such thing as a free dinner. And that has, of course, come to pass. But nevertheless, it's a great honor to have been invited to speak to you and to be able to share in this moment when this service is, I suppose, declared officially open. The 19th century American satirical writer and journalist, known to all of you, I'm sure, but his name is Ambrose Bierce, who compiled, among other things, a satirical lexicon, which he called the Devil's Dictionary. And in that Devil's Dictionary, he defined litigation as a machine which you enter as a pig and exit as a sausage. I think that says a lot about why we're all here today. It sums up in a pithy way the need for alternative methods of resolving disputes between human beings, and the value of the work that you, as trained mediators, do. Mediation is but one of a number of means by which persons in dispute with each other can try and resolve their issues without the delay, stress, and often exorbitant cost of going to court. An English barrister, Trish Dunlop, barrister at law, in an article in the Irish Times a couple of years ago, described mediation very well. She said, quotation, "Mediation is the flexible application of elegant skills towards a creative solution which would not have been possible in court, that is restricted to legal remedies. Unlike the court process, mediation is a voluntary, private, and flexible way of settling disputes. It is interest-based and not rights-based. Flexibility and the desire of the parties who own the problem to also own the solution are essential ingredients." That's the end of her quotation. As a judge, of course, I have no experience of mediation as a dispute resolution tool. But being asked to say a few words today at the opening of your court alternative mediation service has given me a welcome opportunity to reflect on mediation and to consider its place in the future in order to help people in conflict to resolve their issues without resort to traditional and by now prohibitively expensive weapons of legal warfare. Once those weapons of legal warfare are spent and the battle is finally won and lost by one or other of the parties, the scene can be reminiscent of the last act of many a Shakespeare tragedy, where much blood has been spilt, bodies need to be buried, and where those lucky enough to have survived it all are emotionally and psychologically scarred forever. Jim gave us a very interesting excursus through the history of mediation back to Roman times and even Greek times, and in my own wanderings through research for this evening, I came across the Law Reform Commission's consultation paper on alternative dispute resolution. And it notes that some 4,000 years ago, even a couple of thousand years before people that Jim was referring to, in what was then Mesopotamia, now Iraq, a process resembling mediation is evidence in historical records. It was a mandatory process, and it was only after the mediation had been shown to have failed that the parties to the dispute were then free to go out and kill each other. It's a curious phenomenon that in discussions with solicitors and barristers nowadays, many will tell you about how much time they spend and effort they go to trying to persuade their clients to avoid going to court if at all possible. It sounds a bit like a dentist telling you to be sure to wash your teeth 3 times a day, or a tobacco manufacturer encouraging people not to smoke. But I suppose the reality is that the goose that laid the golden egg is now deceased. I have for a long time felt that there is little to be said in favor of the time-honored adversarial system of litigation we have come to know and either love or hate, unless of course one is a lawyer with a busy practice to whom the expense is an inescapable attraction and delay and irrelevance. Any alternative to adversarial litigation is to be preferred as far as the average client is concerned, I suspect. There will, of course, always be the client who insists on his day in court, not because he wants an end to the dispute or even to obtain justice, but simply because he wants a victory. He wants to prove that he was right and the other party was wrong. He wants to emerge from that gladiatorial arena with his opponent's bleeding head held high for all to see, and he is prepared to risk his own head in pursuit of that ambition. Some people will never mediate to a consensus. We as lawyers who are so familiar with the experience of going to court are apt to forget that for the average man or woman, that experience is an unwelcome and an unpleasant one. And for them it is to venture into a world that is unknown to them. They rarely understand what is going on, they are afraid, and that is an entirely justifiable and rational fear of the unknown. Most people never have to go to court during their lives. For anyone who once or twice in his life has a dispute with someone which he cannot sort out over a beer or a cup of tea or even across a desk, the desire to avoid that gladiatorial court arena must be very strong indeed. Until recent years, there was no other way, except perhaps arbitration, which was confined essentially to commercial disputes, where an arbitration clause perhaps mandated arbitration. Delay is an inherent feature of most litigation. Those delays are good reason in themselves to encourage parties to mediate a resolution to their disagreements, no matter what their nature. Delay is nothing new. It could be a problem even in Victorian England. You'll all be aware of the interminable fictional chancery case referred to in Dickens' Bleak House as Jarndyce and Jarndyce. That case went on so long that in due course all the parties and their heirs were dead, and the value of the large estate in dispute had been exhausted in legal costs. It is, of course, a typical Dickens caricature, but the reality behind the caricature can be seen in many cases during the course of any law term in Dublin or elsewhere in the country. And I dare say, in other jurisdictions with which you will all be more familiar than me. Only Dickens could so eloquently put the case for alternative dispute resolution when he described the cause of Jarndyce and Jarndyce in the following way in Bleak House. You'll forgive me if I quote a lengthy paragraph. Jarndyce and Jarndyce drones on, a bit like me. This scarecrow of a suit has in course of time become so complicated that no man alive knows what it means. The parties to it understand it least, but it has been observed that no 2 chancery lawyers can talk about it for 5 minutes without coming to a total disagreement as to all the premises. Innumerable children have been born into the cause, innumerable old people have died out of it. Scores of persons have deliriously found themselves made parties in Jarndyce and Jarndyce without knowing how or why. Whole families have inherited legendary hatreds with the suit. The little plaintiff or defendant who was promised a new rocking horse when Jarndyce and Jarndyce should be settled has grown up, possessed himself of a real horse, and trotted away into another world. Fair wards of court have faded into mothers and grandmothers. A long procession of chancellors has come and gone. The legion of bills in the suit have been transformed into mere bills of mortality. There are not 3 Jarndyces left upon the earth, perhaps, since old Tom Jarndyce, in despair, blew his brains out at a coffee house in Chancery Lane. But Jarndyce and Jarndyce still drags its dreary length before the court, perennially hopeless. That's the end of paragraph. But it does describe, I think, it describes a scene not unfamiliar in some quarters, certainly in the forecourts. And the American experience has been no different. United States Chief Justice Warren Burger wrote an article which appears in Volume 2 of the American Bar Association Journal in 1982 under the title, "Isn't There a Better Way?" He wrote in that article, "The obligation of our profession is, or long has been thought to be, to serve as healers of human conflicts. To fulfill our traditional obligation means that we should provide mechanisms that can produce an acceptable result in the shortest possible time, with the least possible expense, and with a minimum of stress for the participants. That is what justice is about. The law is a tool and not an end in itself. Like any tool, particular judicial mechanisms, procedures, or rules can become obsolete." And at that point, my printer seems to have failed. But the reference to rules becoming obsolete did lead me to the position that I've held for a long time, that our current rules of the superior courts are long overdue for a radical review and overhaul. And I think that any of you who are practicing, and certainly any judges who have practiced in the past, will recognize within the rules of 1986, Superior Court rules, many of the rules that first appeared in the Judicature Acts of 1871, I think. The Judicature Acts provide rules of court with which we are still very, very familiar, and they are no longer, in my view, fit for purpose. The rules facilitate delays in the system rather than eradicate them. Any litigant, be he plaintiff or defendant, who wishes to delay the proceedings he is either undertaken or is defending, can find many a friend within the rules of our superior courts. I think it's time that something was undertaken akin to the Wolf Report in the United Kingdom, or in England and Wales certainly. We've tinkered with case management certainly, and there has been enormous success generated within the commercial court. But there are delays in other areas, even though those delays are shorter than perhaps they were. But I do think, and I go back to my initial point, that the rules of court could be changed in a way that no longer facilitated delay and contained meaningful encouragements to speed and expedition, because delays do add to cost, and the longer a solicitor's file is open and counsel is engaged, the more the cost is going to escalate. So that's a little hobby horse of my own. There are also in the United Kingdom, of course, more recently the Jackson Report reforms in relation to the management of costs from the outset of the case, where the judge, him or herself, will play an active role in trying to control the costs of litigation. And then there are Jackson reforms also in the area of disclosure and so on, all with a view to trying to improve the playing pitch, I suppose, in which litigation is fought. But you, as mediators, are the happy recipients, perhaps, of the inefficiencies, expense and delay inherent in the court system, because you're filling a gap. And perhaps by now it's a much needed gap because of the fact that litigation is something that can be afforded only by the very wealthy, the very courageous, or the very foolhardy. So I'll end with that, on that salutary note. I wish this organization every possible success. You are all evangelistic in your enthusiasm for mediation, and with that enthusiasm I've no doubt that the message will go out, and I certainly as a judge may be the happy recipient of your endeavours if the lists become shorter in due course, but I suspect, like every vacuum, it'll be filled with other areas of law that will have to be fought out. But I wish you luck, I wish you success, and as much money as you can reasonably generate without yourselves destroying the goose that laid the golden egg. So thank you very much.